Welcome to WG University, Weber Gallagher's series of educational programs. This is our general liability webinar series. I'm Brian Calistri, and I'm presenting today with Rob McMahon. We're both in the Philadelphia office of Weber Gallagher. If you'd like to view this webinar again and share it with others to see any of our other Weber Gallagher University, also known as WG University program, please visit our website, which is wglaw.com, and you'll find copies of not only this presentation, but all the other webinar presentations we've done in recent years. Today's presentation is the admissibility of blood alcohol content, also known as BAC. And so let's get right down to it. What brought this on is a recent Pennsylvania Supreme Court opinion in the case of Coughlin versus Massaquoi. I was in court arguing a similar issue, a blood alcohol toxicology issue. When this case came down, it was a death case. This is back in September, about 4 months ago. Huge issue because my case was a fatality case. A technician of a dumbwaiter managed to get his head essentially squished inside the dumbwaiter. And during our discovery process, we learned that toxicology tests done by the coroner revealed that his blood level showed methamphetamine and amphetamine at near fatal levels. Not surprisingly, we get to court. We're about to pick the jury, but just before that, the judge had us do a motion in limine hearing. The plaintiff attorney, not surprisingly, was trying to exclude the evidence of not just the blood alcohol, not just the toxicology report, which was positive for the methamphetamine and the amphetamine, but also exclude our expert who gave an opinion in that regard. We felt like we were going to win the motion going in anyway, but when this case, Coughlin versus Massaquoi, literally came down that morning as I was preparing my oral argument on the motion, when Coughlin versus Massaquoi came in, I knew we were going to win the motion, which ended up being a huge deal because it saved my particular client, who was the installer of that dumbwaiter, a lot of money when we subsequently settled the case at the time of jury selection. So the big thing that I'll talk about today are the types of cases where we as defendants are trying to get this kind of evidence, whether it's a blood alcohol or a toxicology report that indicates some kind of drug in the plaintiff's system, whether it's cocaine or heroin, or in my case it was methamphetamine. I'm going to address it from the plaintiff's standpoint, where we're trying to exclude, we're trying to use it against the plaintiff, and the plaintiff's attorney is trying to exclude that evidence, claiming it's prejudicial or not admissible for some other reason. Then my partner, Rob McMahon, is going to address the issue of that evidence when we are defending a case, and it's, for instance, our driver of a vehicle who is alleged to have been under the influence of alcohol or something else, and we're attempting to exclude that evidence. So I'll start off first, without further ado, if that makes sense, Rob, discussing it from the perspective of us being defendants, trying to utilize that evidence. And as you can imagine, it's powerful evidence. Why? Because once a jury hears that a plaintiff is injured while he or she is under the influence of whether it's alcohol, or particularly something like amphetamines or methamphetamines, all bets are off. Most plaintiff attorneys, even in a plaintiff-friendly venue like Philadelphia, fear they will lose the case. So the plaintiff attorneys really fight hard to keep that evidence out. Using my dumbwaiter case as an example, we had videotape of just before the incident occurred of the technician who was subsequently found by the coroner's toxicology report to have a near fatal level, a near lethal level of methamphetamine in his blood at the time of his death, which was the time of the accident. There was videotape of routine surveillance. This happened at a casino where, as you probably know, there are cameras everywhere. The cameras didn't catch the actual death. The camera was just pointed slightly away from the actual scene of the gruesome death. But it did capture the decedent, who's an elevator technician, coming and going, working around the elevator and dumbwaiter. He looked totally normal. He did not look like someone who a lot of us might picture to be under the influence of methamphetamine. He didn't look like some, jacked up hippie from Breaking Bad. He looked like a normal working guy. That piece of video evidence was utilized by the plaintiff to argue for the judge that it was unfairly prejudicial for us to admit into evidence the fact that there was this toxicology test showing a near lethal level of methamphetamine, and also to allow our expert toxicologist to come into court and convey to the jury that an average person with that level of methamphetamine in his blood or her blood would be prone to fatal judgment errors. So one of the important things of our toxicologist's testimony in this case, it wasn't just that he said that a person who was under that amount of influence of methamphetamine was going to look crazy. Our toxicologist was ready to say that a person under that level of influence was going to act crazy, i.e. exercise extremely poor judgment. So what we had in our case to submit to the jury was the results of the toxicology test and the expert testimony, and we argued that was sufficient to submit the evidence to the jury. Plaintiff's opposition was the evidence was unfairly prejudicial and that we lacked corroborating evidence, such as a fact witness, an eyewitness nearby who would testify that the plaintiff decedent was acting in an irrational or unaccountable fashion, such as you might expect someone under the influence of a methamphetamine. Lo and behold, as we're arguing this motion, Coughlin versus Massaquoi is decided. Coughlin versus Massaquoi, Pennsylvania Supreme Court clarified some issues that had previously been ambiguous with respect to blood alcohol content. Real quickly, what's in Coughlin versus Massaquoi? Very simple case, happened in Philadelphia. Massaquoi's driving along, it's dark, it's night, and hits something. Doesn't know what it is. Discovers subsequently after pulling over it was a person. This person was Mr. Coughlin. Mr. Coughlin was taken to the hospital. He was dead at the scene, but his blood alcohol was over 0.3, which is he was approximately 4 times the legal limit for driving. So blood alcohol, that you've probably heard through experience and knowledge, can be a fatal level of a blood alcohol content being higher than 0.3. But that was the only evidence in the case. Nobody knew how Mr. Coughlin got there, where he'd been drinking, what he'd been doing. All they knew was that he'd been hit by Massaquoi's vehicle. Coughlin's estate then sued Massaquoi for negligence, and at the jury trial, Massaquoi's defense counsel wanted to admit and did admit the testimony of a toxicologist, and the toxicologist's testimony was a person with a blood alcohol level that high of over 0.3 would not only potentially be acting in a appear to be intoxicated, but more importantly would be acting in a irrational capacity, poor judgment, exercise, bad decision making, such as walking on a dark crosswalk where they couldn't be seen. That evidence was admitted at trial. There was ultimately a defense verdict, and the Coughlin estate appealed to the Supreme Court. Went through the Superior Court first. What the Supreme Court held, and this is an important point, was number one, there really is no bright line test for what is or isn't admissible in this context. The plaintiff had argued on appeal that there had to be a corroborating witness to support the admissibility of this evidence, such as somebody who saw Mr. Coughlin at the time acting drunk. using poor judgment. And since there was no such witness in the case, the plaintiff argued the evidence should not be admitted because it wasn't reliable and was overly prejudicial. Supreme Court upheld the lower courts in this case, saying the evidence was appropriately submitted, that there was no requirement that there needed to be corroborating witnesses as to the condition of the plaintiff decedent at or prior to the accident. The court said it was sufficient to simply have the accident itself, the blood alcohol content, and the expert who could testify that a normal person with a blood alcohol level that high was appropriately admissible. And evidence, the court said there was no bright line test. It is left to the discretion of the trial court. However, that does not mean the trial court, and this is the one thing I'd ask to be taken away from our presentation on this part of the issue, the fact that the trial court is left to their discretion on this in this matter does not mean they can do whatever they want. The case law is very clear now that if you have an accident, like in my case where it's unwitnessed, or in the Coughlin case where there are no witnesses to the decedent's conduct before or at the time of the incident, you don't need to have a corroborating witness. It's sufficient to have a blood alcohol test, toxicology test, and an expert testifying to the effect that that test, that blood level, that toxicology level, the effect that would have on someone's judgment, and it could be an average person's judgment, that is sufficient to get the evidence in front of the jury. Coughlin is an important case because it clarifies that when you've got a plaintiff and you've got a blood alcohol test and an expert who's willing to say the blood alcohol level or the drug level would affect their judgment, that evidence comes in, and that's good news from the defense standpoint. I'll turn it over to Rob now, who's going to address it from a dram shop capacity, defending one of these cases, and also from the capacity of a case where we're representing a defendant driver who the allegation is the driver may have been under the influence of whether it's alcohol or a drug at the time of the incident. Rob?
Okay, thanks, Brian. Coughlin is it's an important case, but on my end of things, I'd like to point out that Coughlin, the reaction of the bar to Coughlin, I thought was a little, dare I say, overrated or sort of over emotional. And quite frankly, when although the decision was in favor of the defendant, the plaintiff's bar, ironically, at the end of the day, benefits from this, really. When you're defending, there are two different ways of looking at this. One is if you're defending dram shop cases, which I've done in my past and my experiences defending dram shop cases. Another is if you're in the dram shop case, if you're defending the bar, and the other is if you're defending the allegedly drunk driver. There are two different, drastically two different takes on this, depending on who it is that you're defending, again, from the defense end. In dram shop cases, in my experience, particularly here in Philadelphia, the BAC has always been admissible in a dram shop case, even in the absence of the corroborating eyewitness, despite many chagrined yells and complaints from the defense bar, myself included at trial, when I had a dram shop case where the allegedly drunk tortfeasor was a customer in my bar, and there was nobody there to say what he had looked like at the point of service. So there are two different aspects here. So let's talk about if you're defending the drunk driver. This case, if you're defending the drunk driver, then Coughlin's bad for you. Coughlin essentially holds that you don't need that the BAC can come in and the jury can be allowed to give the weight that they deem appropriate. So if you're defending the drunk driver under the Coughlin holding, your best defense is going to have to be science against science. So you're going to have to go out and get the toxicologist yourself, get your own toxicologist to help you fashion your cross-examination and what type of questions you're going to ask. You're going to cross the plaintiff's toxicologist with. And there you basically are left with science versus science. So your tox is hopefully going to help you fashion your cross. and enable you to ask questions on the science of the taking of the blood or the use of a breathalyzer. When was the blood taken, in relation to the presence of alcohol in the blood, and the science of what they call spiking in the presence of alcohol in the blood. Obviously, if you're hiring a toxicologist, you should be familiar with that toxicologist's prior testimony. It will be used against you when the plaintiff crosses your tox. So you have to be really careful. Make sure you can get as much information and as many prior examination scripts as you can of your own toxicologist. Know what he or she said previously under direct or cross. So at the end of the day, again, if you're defending the allegedly drunk driver, you're left with science versus science. And there's not much more after that other than you have to get a toxicologist and help fashion your cross. The more interesting angle, I think, is if you're defending it's a dram shop case and you're defending the establishment that allegedly served the allegedly drunk tortfeasor, who was probably a co-defendant and who probably, unfortunately for you as representing the bar, only has a 1530 policy. So you're left as the target with the deeper pocket. In those cases, and in my experience, the BAC often came in anyway. I've had cases where I've represented well-known concert establishments here in Philly who have bars in the venue, and I've had cases where there were no corroborating eyewitnesses to say exactly what that plaintiff or exactly what that co-defendant tortfeasor looked like at the time of service. Remember, if you're defending a dram shop case, your touchstone holding is always going to be that the plaintiff has the burden of proving that the drunk tortfeasor was served while visibly intoxicated. So the essence of your defense is going to be still, what did that tortfeasor look like at the point of service? How did they appear? And you have to operate from the assumption that the BAC, and generally speaking, when you get a dram shop case, the first thing you look at is there a BAC on the allegedly drunk tortfeasor? I always hold my breath. If the BAC is bad, and when I say bad, I think usually a 0.16 or above is one of those numbers that jumps off the page at you, and you look at it and you think, uh-oh, how am I going to overcome that? Now, you'll have a tox and you're going to defend just as you would if you had the drunk driver, but you also have the benefit of the served while visibly intoxicated standard. And in the absence of eyewitnesses, you're in still a pretty good space. Now, if the tortfeasor has a BAC of over a 2.0 or 2.5 in those really bad ranges, you have to overcome the public's perception of what I call the myth of legal intoxication. You always hear police attorneys tell you in depositions or in hearings, the driver was legally intoxicated. The tortfeasor was legally intoxicated. That's a myth. There is no such thing as legal intoxication. There is a standard by which our government has decided that you are unfit to operate a motor vehicle if you have a 0.08 or more. Then you are legally intoxicated as to the operation of that vehicle. But the myth of legal intoxication is just that, and you should be prepared to be filing motions in limine to prevent the defense counsel from using that phrase when he's talking about your client, the bar, or the establishment that serves liquor. There is no law against getting drunk in a bar. There is a law against the bartender serving you once you appear drunk. You can get as drunk as a skunk, but until you appear drunk as a skunk, you can still be served. So if you're defending the establishment, what Coughlin tells you is be prepared, as you always were in your practice, that the BAC is coming in. And you have to be prepared to defend the BAC with science, i.e. a toxicologist of your own, but also still do your research, do your legwork, do your investigation, and find out if there are any eyewitnesses to the person being served and what that person looked like at the time of service. You often hear newspaper articles that talk about a tortfeasor's level of alcohol being twice the legal limit. That's another, again, going into the myth of legal intoxication. That's twice the legal limit to operate a motor vehicle if you're 0.16 or above. But again, that's to operate a motor vehicle. So you as a defense attorney, your job right up from the get-go is battling the scary BAC and battling the public's perception of the scary BAC. But you are still left with that defense of what did he look like or what did she look like at the time of service? And that's where your job as a defense attorney comes in. You have to be on guard against it. When the BAC is coming in through their toxicologist, expect their toxicologist to do what is the commonly known phrase of backwards extrapolation, and therein lies the science of their toxicologist saying that the allegedly drunk tortfeasor, if he blew a 2-0 at 2 a.m., would have had a 1-3 at 11 p.m., and with a 1-3 would have been acting a certain way. Then your toxicologist hopefully is going to be able to opine that everyone metabolizes alcohol at different levels and different rates, and everybody's metabolism can be different, and that possibly my 3 beers isn't your 3 beers, as I say as an Irishman. And I have used that in closing arguments before, and I think it has a certain amount of validity if you can get through to the sort of what I call the common sense and logic of the jury. We have all known in our experience people who we call lightweights and who can't handle their liquor, who we all have friends and associates who have had 3 beers and they look visibly intoxicated. We also know people who have 5 or 6 beers don't look visibly intoxicated at all. So these are arguments that you have to make in defending the dram client or the bar itself.
Let me ask you about something in that context, Rob, if it makes sense. This comes up with the Philadelphia Inquirer publishing, I think on Tuesday, the Roy Halladay plane crash. Roy Halladay, of course, a Phillies great pitcher, possibly a potential Hall of Famer. The toxicology test, as reported in the media, showed his blood level was positive for amphetamines, what they also described as a near lethal level. In fact, I went to my case involving methamphetamine that I mentioned with a dumbwaiter and compared the toxicology report in the Halladay case as reported in the media to the one in my case, and the numbers were almost identical. Methamphetamine and amphetamine, similar test results, similar measurements. So the arguments made in these cases many times is habituation, is that the user uses so much of this product, whether it's alcohol or some kind of drug, that near fatal, near lethal doesn't have any meaning because they're used to using it. In fact, one of the comments about Halladay in the newspaper, which I can't validate or vouch for, but it was in the newspaper, was that he may have been at that high a level only because he was a habitual user and had built up that kind of resistance. How do you deal with that when it's something that's raised, and it could be raised either against you or you could use it as your defense?
Well, it's an interesting case. If you looked at the article about the levels in his system, I thought the first thing I was thinking was I was guessing somewhere down the line his family is going to pursue possibly a products case against the airplane manufacturer.
Right.
So we're thinking in terms of that. I would think that if you're defending again, I'm using these hypotheticals. If you're defending the airplane manufacturer, you are certainly going to have a toxicologist who is going to opine that he had dangerously high levels that were affecting not only his judgment but his physical performance. They then will have their own toxicologist who may opine that if he was an habitual user, his levels were so high, but they weren't, if I'm understanding your point correctly, that they weren't, that in someone else they might have been intoxicating, if you will. On him, it may not have been because of the level built up. Then again, therein lies, and then the sort of the burden
Right.
shifts back. And then if you're defending the airline manufacturer, I think you start doing your investigation, get your detectives out, and you start interviewing his friends and start finding out whether or not anybody's willing to talk about Roy Halladay's use of amphetamines and how habitual it was and how often he used these. And if other people are going to say, I knew Roy, and yes, I knew he was taking this and that. There's
And of
also
course, this is
Ambien
just
in his
based
system.
on what's in the media. We have no independent evidence. It's all hypothetical, but the information is out there, and it is unfortunately painfully similar to the kind of cases you and I regularly deal with. The habituation issue is a big one because it was going to be used in my case by the plaintiff attorney, had we not settled, as his backup argument, which is that this high level that you guys are talking about was is not as significant as you think. Why? Because the evidence of record was the decedent had been in Narcotics Anonymous, had been a career user, had been functional, had a great employment record, had actually a great family, and had no prior impact on his work life. But he had been a user over actually more than a decade. So the habituation defense is something that I've seen in this context.
It's interesting because it's sort of like as I said at the beginning, Coughlin is, although it ends up being favorable to the defendant, it's sort of what's good for the goose is good for the gander with regard to the usual arguments of the plaintiff's bar. Now under Coughlin, I would think, generally speaking, most plaintiffs practitioners would actually secretly like Coughlin because it helps them with dram shop cases. For once, the BAC was helpful to the defendant. But I would think, again, using the Halladay example, again, that's going to be sort of a combination of science versus science, and then also doing your legwork and having to find out if that's the argument being made by Roy Halladay's expert, the habituation or the presence of levels. In other words, I don't know, your 4 amphetamines aren't my 3 amphetamines. It will be interesting to see how that works out. But I would think then comes in the other evidence that you have to find out beyond the science of his use, how often, his pharmacy records, his prescription records, his family doctor records, all sorts of things like that.
I would say the takeaway from Coughlin, and actually if you're defending a case where the plaintiff is the party that is the one that's got the blood alcohol content or the toxicology result indicating a level of drugs in their blood, get a toxicologist and make sure the toxicologist's report states that level will foul the user's judgment. They will be disposed to exercise poor judgment because that makes their conduct contributorily negligent. And that's my main takeaway from Coughlin. Rob has told you his takeaway. So I see our time is just about up. So without further ado, we'll wrap this up. Thank you so much for attending the WG University the admissibility of blood alcohol content seminar. You can learn more about this program and other Weber Gallagher events at wglaw.com/WG-university. Thanks very much for your time today.
Thank you.